Good morning.
Good morning.
I may be permitted to make a mention, my lords. Writ appeal for the past 14 months, it hasn't been listed. Fresh admission. My lords also directed.
Week after.
Yes, week after.
My lords had already directed the matter to.
Yes, fresh matter. Our instruction is that all should come up.
All matters should come up. Why more than 2 weeks? In fact, in other states, more than 2 weeks matter will not be kept in the cupboards at all. It has to come before the court with objections also. At least you will be in a position to answer your claims. That matter has come. Otherwise, he'll ask you. 1.5 years you have not done anything.
My lords had directed the matter to get listed today.
But said that it will come.
Today means you have to mention it.
I have mentioned that.
Because it is just possible that because the list is scrapped, so they are distributing it.
My lords, I have already mentioned.
And you don't realize what is exactly happening. So please mention that by this order, the direction to the district. So I should
Grateful.
Lordship, may I mention that? On July 2nd, Lordship had given a judgment on the regularization issue. Last time, Lordship had appeared different matter. One of the matters skipped, Lordship, which is the covered matter on the same.
Covered matter.
And we take up tomorrow, and it's only similar identical issues, Lordship. I have the order also.
I may be permitted to mention.
provide it to the
To other side also. If it is covered, just looking.
I'll intimate. He was appearing the matter.
My lord, I want to mention, my lord, in a matrimonial appeal, my lord was pleased to direct me for deposit of 50% of the digital dues, which I have not been able to deposit within the time. But I sincerely want to deposit. So unless because it was conditional precedent for stay of further proceeding execution case. I am the husband. I want to. I want that
the payment.
extension.
Of payment. But have you brought some money?
No, money I have not. I have given I filed an IA, including a copy of the medical certificate of my father. That knee replacement of knee of my father, I have spent rupees 2 lakhs just last month. I am ready to pay because I want the family to pay it.
When do you?
My lord.
When do you?
I have requested for tomorrow, but
All right, but tomorrow, day after tomorrow. Only extension, na?
only extension.
But you have to bring some money. Money attracts us.
Thank you.
Yes. It was Carlyle who said, money is my God and how to get it is my religion. Thomas Carlyle. Yeah.
Excuse me. You will be teacher regulation government single base allow the matter government file this writ appeal.
When do you want?
2023 madam.
Huh?
2023 madam.
23
Not
madam.
yet admitted or after notice?
After notice.
After notice, it takes time. You see, we are taking up much older time.
It's already
So in August
retired.
last week.
August last week. Yes.
That also send a good message when somebody is mentioning fresh matter is not taken up.
Today or day after?
Any urgency? What is the urgency? How can we take today? The other side has to be.
Tomorrow, my lord,
2023 matter for after notice hearing.
my lord.
How can we prioritize when 2014 matters are listed before us?
Day after tomorrow.
We'll see. Third week.
Send this matter to mediation. Mediation report has come, Lord.
Report has come.
Let us come.
Positive or negative?
Both are agreed to stay.
Agreed.
No,
Not agreed to stay together. Which year matter?
to 24.
24. That will come. There are many 2009, 10, 12 matters now. This was the third week of August. If we had agreed to stay together, we would have taken immediate.
Both are not agreed in that.
Let us see.
Page 2,
Region South.
page 3, 11 to 12, page 3, 13 to 15, page 4, 16 to 17.
I made pardon, Melody. Item number 18. Mr. Popular from Russia, senior advocate, has been engaged in this case. He is not available to be in absence this month.
When do you want?
Next week, Monday.
Next week we have difficulty, but a week after next week do that.
I understand.
Week after next, at the request of inform your friend also.
Yes, I mean,
Item 20 may be kindly be taken up.
For 22nd July.
Item 20.
20.
May be taken up 1 week after. Press matter.
2 weeks. At the request of. Inform your friend also.
State company.
Yes.
Page 5, 23 to 28, Case 3, 29-35.
My lord, I am in 32 item, and for the OP and petitioner is also present. The sitting
Personally present.
petitioner.
No, I am for the appellant. My my senior, my friend is for respondent. He seeks time on the ground of illness of his senior.
We'll give short time. We will give some time.
My lord, actually, his senior friend is also really ill,
So we will give.
and he has intimated me very much ill.
It's not admin. How much time you can adjourn the matter? In both
2 weeks.
2 weeks, my lord.
Call after 2 weeks. On the ill health of arguing counsel appearing for the husband.
Respondent.
Yes. Next.
36 to 39.
Case 7, 36-39. Case 8,
All right,
40-45. Item 4.
May I please?
Yes.
My lord, at the outset, I would like to bring it to lordship's notice. In the present case, a common judgment passed by the learned single judge in 2 writ petitions is under challenge. Common judgment passed in 2 writ petitions is under challenge. This is the one writ appeal filed by me. Another writ appeal bearing number 3178 of 2024 that has not been listed today. My lord? My lord, my prayer is, if your lordship will be pleased to call this matter tomorrow, along with that, then you at one go, your lordship can take up the hearing. My lord, in the no, my lord, urgency is there. My lord, it's a case, my lord, where your lordship will be, my lord, with all humility to myself, my lord, here is a case where the settled law.
Sir, we are not doing one independent hearing of both the.
No, my lord.
This challenge, you are 7
My lord, I want it. My lord.
You want 7 of 24 or 5?
24.
2024.
So your lordship call it on Friday. Friday. Because it's a question of appointment. An ineligible candidate who has submitted his application after the cutoff date. My lord, we have, my lord, it's a judgment passed on 9th of October 2024. Within the period of limitation, immediately in the month of October itself, I have filed the appeal, but it has not come up before Lordship's board. So that is the thing. Obviously.
Yes. Yeah.
Item 5.
May I please, your lordship. Here the opposite party numbers 2 and 3 in the petition are the appellants herein challenging the order rejecting the review petition. Well, that order passed in the review petition, my lord, may kindly turn to at page. Well, here, my lord, the disciplinary proceeding was initiated against the respondent number 1 on the allegation that though the respondent was an assistant teacher of the school, well, he misbehaved with a class 7 student. So accordingly, DP was initiated. Molestation. Yes. So accordingly, the draft charges were framed. He was called upon to show cause. So reply was not found satisfactory. So regular disciplinary proceeding inquiry was held. Inquiry report was submitted. He was found guilty. So thereafter, what the disciplinary authority did, well, instead of sending the inquiry report at the first instance, so along with the proposed penalty, the disciplinary authority forwarded the inquiry report. So accordingly, he submitted the reply and final order was passed for dismissing the from service. So that was challenged in appeal. So appeal, the order of dismissal was confirmed. That order of dismissal by the disciplinary authority as well as by the appellate authority was challenged in a review, in a writ petition before the Honorable Single Judge. So that was allowed on two grounds. That the disciplinary proceeding was initiated by an incompetent authority. Secondly, that violation of rule that instead of forwarding the inquiry report, so along with the yes, so that so for ultimately, what since there was violation of the principle of natural justice, so far as first competency, we have the power, and accordingly we filed the review petition indicating. Yes, my lord may kindly see. No, the Honorable Single Judge held that yes.
Before that,
yes. My lord may kindly go to page 44. Yes. This was the notice calling upon him to, along with the draft charges.
General Manager.
Yes, General Manager, my lord may kindly see 25/9/2013. This is the date. Yes.
You show us General Manager has not passed.
Yes, that rule I am placing, my lord. My lord may kindly rule I have enclosed to the writ appeal, page 116 at Annexure 6.
6.
Annexure 6 is the rule. Page 123, Rule 12.
Yeah.
Yes. The respondent is a assistant teacher. He belongs to grade 3. Yes, my lord, at page 123, Rule 12. We are concerned with C. Director shall be the disciplinary authority in respect of all grade 3 and grade 4 employees. My lord, may kindly. No, my lord, no, there is the catch, my lord. My lord, may kindly see just after C, yardstick is there, star is there, then 3 is there.
3.
Yes. Now 3 has been described at the bottom, my lord, may kindly see. First, it was amended in 300 board. Yes, I am going to that. Yes, my lord wanted to know whether on the date when the so-called notice was issued, September 2013, Chief General Manager was the authority or not. That I am driving at only.
Was he in charge or regular?
No, he was the regular.
I will come to page number 45.
Yes, P&A in charge. Yes.
The Supreme Court has said, in charge holder of the office cannot discharge the substantive requirements. Lovely judges are not referred into that. No. It is staring at us. An in charge holder of the office cannot discharge the substantive functions. Contrary notification is there.
That was also never.
Take out Basavaraj Dhotrad. Take out Karnataka. Basavaraj Dhotrad versus Managing Director.
The case of the writ petitioner in ground E. Yes.
You are only wasting our time. Then we are telling you, an in charge officer cannot do the substantive duties. He is in charge. An independent charge may do. An in charge cannot. This is what Justice Ramajoy says in his services under the state. Take out that judgment. Justice Najir Saab's judgment. ILR 2006 Karnataka 3163.
Was he notified to carry out all the functions or function as assigned to the managing chairman or managing director?
No. Well, the rule what was prevailing on the date that the
Question
chief.
of rule will not arise because rule contemplates
So that-
regular general manager.
Yes. Rule contemplate chief general manager.
That's what.
General.
Regular chief general manager.
Yes.
Now, person who is here is in charge general manager.
Yes.
An in charge officer cannot discharge the substantive function is the law.
It's only your lordship may grant me 3 days time. I'll verify from the other because that point was never argued, so I could not
But
verify.
this is open to us now. It's a
Yes.
proceeding.
Yes.
So we have to see the record.
No, I can assist to that point.
Just look into that. That's it.
Rather the second show cause and all that, that can be looked into a different way. The actual prejudice, whether he was,
But competence goes to the
but competence goes to the root.
Yes.
As it was.
Well, see that point I have not verified. Your lordship grant me some time. I will verify from the authority.
Okay. Call next week for further hearing. Yes,
24th.
24th.
One day, your lordship, 21st.
No, 24th to become 22nd.
Yes, 22nd. madam.
22nd.
Just the Justice Ramajoy's services under the state. Very often we tell this so that you will come after reading the papers. Yes.
Can you pass over this matter?
Pass over.
Pass it. Obliged.
Item 8.
Your Worship. That since the matter is very urgent because of the admission into the technical institution engineering courses, Millard, on my request, I have served advance notice on AICT, my learned
also here.
Mr. and Mr.
Sorry to argue.
Millard.
They are here.
Millard, here the only point before your Lordship for adjudication is, your Lordship may kindly turn to Annexure 2, that is the AICT approval for the present academic year 2025-26.
AICT Engineering College.
Engineering College, Millard.
AICT approval is granted.
In respect of 2 subjects in integrated MTech, that is 56. You may kindly come to very same annexure 56.
We are asking you.
Miller.
AICT approval is dated.
Miller. J is not uploading.
Date.
Approval is 9th April, Miller, 2025, Miller.
9/4/25.
Miller.
That is in respect of 2 subjects.
In respect of other existing subject, additional subject too.
Additional subjects.
Miller. And that subject is at page 56.
We will not turn any page.
I'm sorry, Miller.
We believe you.
Miller, oblige,
Just
Miller.
mislead us.
Miller.
Additional subject. Then what happened?
That AICT approval order itself is communicated to the BPUT as well as the government of Odisha from the Department of AICT. That is the procedure, Miller. That is also there. Record itself reveals it, Miller. Then, Miller, after getting of this AICT approval, Miller, we intimated and requested the BPUT, Miller, that is the affiliating university, OP number 4 before Lordship, for accordingly do the next course of action.
What next course of action?
Miller, keeping in view of the AICT approval, they should grant affiliation, Miller, to me. Because so far the affiliation, AICT approval is accorded year-wise, Miller. Affiliation is also granted year-wise, Miller. And as per the BPUCT own statute procedure, Miller, that is the procedure of the AICT, once of the requisite criteria for granting affiliation is AICT approval. Then we produce the AICT approval, Miller.
Which is the rule which regulates granting of affiliation?
They do not. Yours.
What is the procedure for who appears for the university?
Miller.
For the university, who appears?
I want.
What is the competitive procedure of?
Your Lordship.
Your Lordship, see, that is the office order number 3655, annexure 4, running page 16.
What does it say?
That is the office order says not to Vice Chancellor appointed a constituted committee to verify the college and check
All right. When was it communicated?
31/5/2025.
Fairly quick. 9/4/18. 31/5 it is communicated. Of course, communicated to last day.
9/4 communicated to university.
Or 21/5.
Hopefully, yes. University communicates to also the college that we are constituted a committee and we have to get.
When it was communicated to you?
31/5/2025 last blood.
9/4 was communicated to you when? That's the question. 9/4 was you received one when?
1/5/2025 by the annexure 3 non-inclusive time.
1/5.
Yes, that's
It is communicated on 1/5.
yes.
Then what did you do?
13/5/2020 constituted a committee as per the procedure to verify the college and is everything whether he is capable enough to 60 seat or all these things. The later committee has to examine the proposal with reference to AAC norms and he has taken your handbook and submit his view on the issue of NOC by the university within 7 days.
1 second. Which will be the last date for admission of students in the academic year?
Lord, that is
And that is fixed by you, by the university.
Lord, no, Lord, that is he Lord needs approval.
Milord,
Kindly don't disturb us. He is
no, my lord, I had a query, Milord, regarding the last date.
not to you, sir.
Last date, as per the Parasbanath guidelines of Supreme Court, that is 15th August always.
15th August.
Yes. That is Parasbanath case, Milord.
Please, sir, take it. So 31/5, the report is to be given within 7 days. Mr. Shripad.
31/5 office order issued is form the committee to examine all these issues and verify.
Kindly look at the third paragraph.
Yes.
The committee is to kindly read.
Committee to examine the proposal reference to ASC norms, ASC the approval handbook and submit a view on the NOC by the university within 7 days.
So 7 days. 7 days. Where is that?
Next page, you will also see
7 days from?
From 1/5.
13/5.
13/5 means 1/6. That should be
So
7.
we are asking you, why did you take 1 month for constitution
That is
of
what
the committee?
yes, that is what for I taken. So because yesterday I have received the copies. That is what for Milord I seek instruction. I will also not ask for that. Why Milord? Because in between Milord, they may take time to not to allow us to because of their difficulties or some other difficulties. Some members may not be able.
Then we will call it tomorrow.
Yes.
That's why kindly look at 61.
Hey, Milord, 61 kindly have a glance. 61. Does not been recommended.
You have not recommended.
No, Milord.
On the ground?
Milord, ground Milord is not reflected yet. It won't be communicated. It is in no university only mentioned are not recommended for integrated computer science engineering within intake of 66. That is what is mentioned. I have to check what is why it has not been granted, what is the deficiency in the college, and what
should know.
He must know, but
how he will know unless university communicates?
But it was in your statement was recorded in presence of the college personnel. All this verification is in presence of the college. What is the laboratories, a strength of HOD, strength of lecture, and all these things visualize. Then only the empower the university to grant the NOC. That is what the usual procedure. I am not able to know whether what ground it has.
Tomorrow.
Day after tomorrow. Day after
Milord, tomorrow another identical matter has been fixed up by your lordship, my learned friend. Tomorrow, Milord. Another identical.
University is where? How many?
Raulkal. Raulkal. The law officer is not in a medical. That is what the problem is.
300.
The law officer is in medical. That is where the problem is. Somebody has to take charge. So tomorrow may not be possible. 1-2 days.
Your lordship may fix up Monday, Milord, because day after.
It's not. Smart.
Wednesday, 22nd.
22nd.
Obliged.
All right.
Yes. Milord, your lordship may kindly just appreciate.
Reserve your argument.
Wait.
Come out.
Obliged, Milord.
They do not answer. You are trying to support him or what?
Whether your client is behind.
No, Milord. My client is now watchful in the virtual mode nowadays, Milord.
On 22nd. All this matter.
Overall, sir, I need time because I have not yet received the instruction.
Yes,
Now we are given up to the
Much obliged.
But tomorrow you have to mention that when the matter
Yes,
is.
yes.
Das knows, so Das knows it, but you mention.
One thing, Apex Court said in 2-3 judgments that in educational matters, the affiliating bodies have to work on war footing because they should know what will happen. Otherwise, 1 year will be lost.
Definitely.
Therefore, 1 month, why the university slept over?
Yes.
That you have to answer.
That is the point.
Yes.
I don't mind.
7. First our matter. You want to argue? Where is your friend? State. Yes.
And the matter regarding non-acceptance of resignation of the petitioners, that is so petitioner resignation at answer 7, my lord.
Speak loudly as we are speaking.
Okay, my lord. The petitioner is surrendered his tender his resignation, but it is not accepted by the opposite party number 1.
Resignation is not accepted.
Accepted. Thrice she has filed. She is working as salaried woman for the Lord and District Judge.
Why? What is the reason they say?
Reason she is a lady and she is staying in Bhubaneswar with her parents and she.
No. Why it is not accepted? Why they have what they
My lord, your lordship can have a glass to Annexure 7. Page 19. With reference to the subject matter, I am directed to state that the tender by you dated has not been accepted by this office. My lord.
Lord Mountbatten used to say that way. Well, who is the respondent?
Respondent.
Registrar Civil
Your
Court.
Lord, the Civil Court Registrar and the District Judge Bhadrak.
Why? What is the reason? If he wants to quit and if he is in a mood to quit, can you make him work?
Obviously.
You can withhold the acceptance only if there is some disciplinary proceeding. Or if she has put a condition.
Probation or any other thing.
Such other, no.
But so far the page 19 speaks about there's nothing.
No, it is like Lord Mountbatten's order.
Prior to this.
No reason. Your resignation letter is rejected. What is that? How can they say that?
The resignation letter she has tendered and thrice she has rejected. She has been.
This matter, this is which matter? First time
This is first time it is coming.
AGA, Mr. Mohanty is requested to accept notice for the respondents. Full stop. Since a short point is involved as to the acceptance of resignation, come on, call this matter on 22nd, 23rd.
I will call contact person.
Yes.
Marty, the standing examination because this jurisprudence has not evolved.
No, that's what.
Why it will not be accepted?
He may not get the benefit of past service.
That's it. Keeping in view their length of service.
You see what Apex Court said in Indira Nehru Gandhi. The question arose relating the resignation of Mr. Yashpal, who was working for Indira Gandhi, Srimati Indira Gandhi, in Indira Nehru Gandhi. That was the issue. When resignation takes effect, that has been discussed by the 5-judge bench decision of the Apex Court. Right to be in job includes right to quit the job unless your rules regulate it. For judges, we can quit the jobs just by writing the letter to the person. Acceptance and other things are not necessary. But got a point. Therefore, you have to come out with a strong reason. Why you and how can you make a person who does not want to work? You will pay salary without working then. These aspects are.
It is that condition is there.
Just see why they
Once
have.
an employee for all the time to come. That
It's not a slave.
It has not to. It has not yet to come in our.
Jurisprudence.
Let me take
It's not a slave.
because can the notice be to the
Yes.
respondent number 2?
Two also.
I mean say OP number 2.
OP number, who is OP number?
OP number 2 is the register civil court. One is the
Very well.
Notice is not required, sir.
One and you will appear for 2.
Notice is not required in this case.
No.
Otherwise,
We do not know what you have done there. Yes.
Next notice to 1 and 2 then.
Issue.
Speed post.
Notice.
3 days.
Sir, only instruction that can be solved because
No. We direct the court to not to issue notice.
no, this is my prayer. This is my prayer. I am not.
No, it's not right. You have made parties. Parties have to be heard in the matter.
No, I will take instruction.
Very well.
Apart from that, but
Notice
let
also.
the notice go
Issue.
by the detail convenient.
Issue usual notice to the respondent first time. In addition to that, Sri Mohanty is requested to accept notice for the respondents. Petitioner to serve copies of the case papers to the learned AGA immediately.
That may kindly be fixed. That
Post immediately after service. Immediately after service.
This is usual course, not speed post or registered post. He has been requested also.
No, I will take instruction after.
Take this.
I will speed post.
Just looking. Sudhindra Rao versus Pollution Control Board.
Okay.
Of course, in GA department, it is a circular, it is a dimming provision that if it will not be accepted
Taken,
for a
deemed
period
to
of
have
3
been
months,
accepted.
then it is deemed to be accepted.
Correct.
However, I will take instruction, it will
That's just
suffice all.
The main provision is the BRS.
Item 9.
May I please your answer?
Copy has not been circulated. Copy.
I have served
Give
the
one more
copy.
copy.
Without serving the copy,
Give one more
candidate
copy.
that's it.
Give one more copy.
Yes. I'll prove.
Will pass over or you'll have some other day?
Next week.
All right, next week.
Obliged.
By next week, you can instruction also.
Yes.
Next.
Item 10.
Item 10 Miller. Next week, Miller.
Next chapter.
Item 11.
Item 11.
Last occasion I noticed issued and it has met sufficient.
Is it?
They dated on 25/6/2025.
The matter arising under?
Well, this is CRLLP 370 against the challenge, the order of acquittal.
This is which place? This is.
This is at this is at place Gondia and Denkana. Notice it has been made sufficient.
Police notice.
What is the police matter? Police notice. Leave to be granted.
Yes, ma'am.
Offenses are?
The offenses are
This is LP 32.
this is LP 32, Miller, 2019.
He has been punished, post punishment.
Yes.
The period of incarceration already undergone. Look at page 19 of the document. Hearing on the question of sentence.
Yes, ma'am. Convict is found to have committed offense 30
years. 8 years already imposed on him.
undergone.
So how much enhancement you can make it? Maximum punishment you are arguing for maximum punishment of 10 years.
10 years.
8 years is already.
30 years.
Kindly check it. Kindly check it. It is not. It's a little irregular.
304 party.
Next week.
Next week?
Next week.
Next week.
And that delay is 32 there. That can be notice made sufficient.
Application for a delay supported by affidavit is favored since plausible explanation is offered for the short delay of 32 days. First. Delay cut out.
Item 14.
14 Miller site paper net legal arts. It's my fault that letter has not been issued to the concerned IIC for
2 weeks after.
2 weeks. Call up. 2 weeks. That's the request.
Yes.
Notice should be supposed.
Yes.
Item 15.
It's by appearing in this item 15 for 5 matters, Lordship.
Yes.
I'll hand over the list, Lordships, of the matters I'm appearing in.
There are other 5 matters.
Six matters tagged, except the first item, Lordships.
We'll call these matters along with those.
No, they are all listed.
All they are listed now.
Yes, madam. I'm appending 5 matters. I've given the list.
Yeah. Yes, what is the matter?
So, regularization of health workers, my lords. Initially,
Not covered.
the issue is covered by Supreme Court, my lords. But in the first round, Supreme Court said that the question of law is kept open. Because of delay and latches, they dismissed the SLP. In the second round, the same issue has been decided by the Supreme Court, and Lordships recollect.
Is it true?
Mishra. Yes, Mr. Amit Mishra and subsequently Ashok Kumar.
So let me start with a copy.
Sir,
Previous,
we'll call it tomorrow.
submit. If they are covered, then I will keep.
Only that 93 circular is there, my lord. 2013. That the period.
If they work in that NRK.
After there is no problem, Mana, that is accepted.
See that.
But the date of regularization, it is which is latter one, which speaks about the
actual date of regulation.
Just look into that judgment also. It may help you also.
Yes. Well, before parting, Lordship, may I read this 3 paragraphs the Honorable Supreme Court has said?
Samantha, can you explain the evidence of the earlier judgment of ours?
Yes, my lords. My lords, I provide a copy. I have a single copy, my lords. I'll go into more.
Only the reference will.
My lords, in the paper book I have handed over, my lords.
No, reference. If you give
Yes, my lords, I have given a reference. My lords, I have handed a 2-page note, Lordships, recently, just now, my lords. In that, I have mentioned around 8 to 10 matters which were referred by the state to Supreme Court. They were all tagged to SLP 4253 of 2021, Lordships. And 4253 has been dismissed by Supreme Court. And it is the ground of the state in the writ appeal, last ground. That is because this SLP is pending for the Supreme Court, so we can't extend the benefit to them. And that issue has been settled in 4253 on 16th April 2024.
in
Ashok, yes, my lords. Lordships. It's a 2-page note, my lords, may have a look at it. From 15th March 2021, all the matters have been tagged to it.
Examine the SLP no more.
The SLU status.
just look into. Give one note to.
Miss, I have supplied them a note.
Judgment.
We'll call this matter
Tomorrow or day after?
Yes, tomorrow.
tomorrow.
Or day after?
This short point involved, Lordships.
But he wants one more.
Yes, please, Lordship.
Day after.
Yes, he is bound by his own grounds in this ground of appeal, my lords.
Right.
And they are relying on the Supreme Court matter, which is already decided on 16th April 2024. Pursuant to that order, they have filed writ appeals also.
Okay. Yes.
Mr. Samantra, if you are satisfied with date of regularization, then dictate a little early. It's more kind of mediation.
Well, Supreme Court gives
you talk to your friend. So
well, he is considered.
Do we not reopen anything? Or
No, he is quite considered. Well, Supreme Court gives the date of appointment, but I am concerned with the date of regularization that is on the before to that.
Only we are saying on 17th November 2013, date was barred. Yes. They have been regularized from 18th. And as per the notification, it is which is latter one.
No, I am not dealing with the first item.
That is the crux of
I am not dealing with the first item. I am dealing with the rest of the items.
I mean, kept in the first item. Let me take the matter. I think.
First, the first item may be detagged because the rest of the
different case.
Yes, Millers. Well, there is a delay of 964 days or something. The first item that goes to Pradhan or something like that.
First matter to be detached from.
Let it be there on that day.
It will create confusion.
Mr. Sahoo is there.
Read a bit.
Mr. Sahoo, what do you say?
Because Sahoo is also there
In the first item, that is slightly different to other items.
Sir, we are doing it differently, sir. We are not mixing it up.
My lord, in that item, my lord, 974 days of delay is there.
You are agreeing for condonation, sir. That is the
And that similar issue is already decided by the
974 Supreme Court has demanded to us 400 something.
Yes.
We are now
974, my lord.
600 days they have said that there could not have been
Dismissal of.
lock and barrel dismissal of all writ petitions. That's the difficulty. So
We'll condone delay. Then on merits we can take up on the day after tomorrow.
Yes,
That may be listed, detag and listed in the separate heading.
No, we'll hear it separately only. We let
on that date also this can be separated up to
separately. We'll pass
putting in
separate
fact and circumstances of it.
What confusion? There is nothing like confusion.
I have added the list in which I am appearing.
State appeal.
Well, sir, tomorrow, the first item may be requested to tomorrow, and the rest may be day after tomorrow.
Will you accept any amount for that delay? Money will satisfy the client because we are also
satisfy everything. You take money.
I will satisfy my lord. The identical issue is already decided.
He is not interested in money, my lord. He is interested in order.
Maybe he is instructed that way. Yes. State appeal is preferred after bringing a long delay of 900 and odd days.
17 days.
First time. An application supported by the affidavit seeks its condonation. First time. Learned IGA appearing for the state submits that in matters of delay, state stands on a different footing, wherein applications have to be considered with lenient.
COVID is there, my lord.
Well, COVID,
First time.
after March COVID.
No, this must be after COVID. 900 days comes 13/4/21.
Well, they cannot take the century benefit of COVID.
13/4/21 up to March 2022.
February 22.
So COVID period is
Further extended 35
of the period falls into COVID.
13/4 is peak COVID of second phase.
Correct.
But they are lacking to the century.
Last was 35/2022.
During the run of the limitation period, a part to the fall, the fall into the COVID coverage period. First up, there are some arguable points on merits also. First, next paragraph. Learned counsel appearing for the respondent employee vehemently opposes the application, contending that delay is too long to be condoned. 7. The explanation offered is also not plausible. Therefore, the application should be negatived. Next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered view that a great injustice would be caused to the states should this application be rejected, inasmuch as such rejection would result into summary dismissal of the appeal itself. First, that is not a happy thing to happen. First, ordinarily, the legal battle should be fought on merits. First, after all, condonation of delay would not add any merits to the case of appellant to the disadvantage of the other side. First, what would happen is matter would be considered on its intrinsic merits. First, there is some explanation which we find is plausible. First, next, in the above circumstances, application having been favored, delay is condoned, subject to the appellant paying a sum of rupees 2,500 to the respondent employee immediately. Because you have to post this matter or separately, within 2 weeks you will do that. Within 2 weeks. First, post this matter on the proof of such payment. First, if payment is not made within 2 weeks, application stands rejected. And as a consequence, appeal as well.
You put a delay of 922 days.
One line, 922 days. Detach this matter from the rest.
The rest are taken up tomorrow, lordships.
Other rest, day after. He said day after.
Grateful.
Yes.
Last one is posted to my lord.
Other matters, not listed, please give the list.
Lords, I have supplied the list in 2 pages, all the matters which I am appearing, lords, are now listed.
Shall be listed along with this matter. Provide the list to Mr. Mahathir.
Yes, but I have provided.
My lord, which date the first one
Yes.
is posted?
2 weeks after. Unless they pay, they will not.
The lordship may fix the date, otherwise they are not listing them.
We have said within 2 weeks, if they don't pay, appeal will be dismissed. That benefit you will have. Need not argue it. The only thing is you have to share your fees with us.
Immediately after 2 weeks, the matter may be listed. Your lordship may.
We said that already.
30th of July 2025.
2 weeks.
The calculation is by after Supreme Court judgment in re contagion. Wrong calculation. The delay should be around reduced by 400 days.
Then it comes to 600 or
520.
520. Thereafter, then that judgment is applied, where 600 odd is condoned.
Because we are now carrying about
29 February 2022 is the credit period. They filed November 2023. After 1 year, 7 months.
The issue is now covered by Supreme Court, so they can have the consolation of delay condoned.
That's one.
Grateful, Lordship.
Yes.
Appeal preferred by the state millers, it's a 78 delay. That's 78.
What is on merits?
Merits is that millers on improper calculation, the respondent number 1 has been engaged as a Shiksha Sahayak. Thereafter, on complaint, on verification that on for the extra optional in matric miller, they have added more mark, excess mark. Thereafter, after verifications, millers the respondent disengaged. Thereafter, preferred number of read petition, 2 number of read petition. In there, this honorable court directed to collector to consider their case and dispose of representation has been disposed of and confirm the disengagement order. Thereafter, millers prefer this read petitions that honorable single directed that to re-engage him as a Shiksha Sahayak because that the respondent has no fault of that, millers. In fact, millers
no fault means the guideline is very clear.
Yes,
calculation of the percentage of marks in matriculation, HSC. The addition of extra marks.
That is deduction of the marks.
So what is the guideline? So how the court has dealt with that?
That millers.
The no fault is that because he did not calculate, you calculated. That's the opinion of the court. Whoever may calculate, but the calculation.
Paragraph 11 of the order, miller.
The guideline, kindly show the guideline first.
You can
Guidelines, millers.
You can keep that door open.
That's
half open at least. Otherwise, it may be broken also and it disturbs us. Keep that door.
That is the millers.
Yeah.
The page 70. Page 70.
Page 70.
Millers.
70.
70. Optional mark. The marks secured in the fourth optional or extra optional subject to HSC exemption is to be deducted from the mark for arriving the effective percentage of mark.
Which paragraph you are reading?
The first paragraph, page 70.
First paragraph. The marks
1
secured in fourth optional or extra optional subject in HSC examination is to be deducted from the total mark for arriving at the effective percentage of the mark. If that is done,
after deduction, the respondent one secured 42.68%.
42.68%.
Those are in waiting list: Basanti Parida, Prabhati Mishra, and Prasanti Lata Das. Secured millers 43.62, 42.93, and 42.90 respectively. Thereafter, miller, after disengagement, both Basanti Parida and Prabhat Mishra have been engaged.
Because they have scored more.
Yes.
And
their score is?
Score is millers Basanti Parida 43.62.
Other
Prabhat Mishra is 42.93. Whereas the respondent one
42.68.
scored 42.68.
What do you say, brother?
Any case law, because the short point.
He has been sought on us.
No, because you are the writ petition.
Yes, Your Honor.
So did not argue on the
Paragraph 19 and 20 of the order.
Mr. Parida, the question is very simple. The writ petition is allowed on the premises that the calculation of marks, percentage of marks, is a mistake on their part, not attributable to the applicant. I hope that's you agree there, or you do not agree. So suppose somebody else also calculates the calculation is wrong. Attribution, is it important? Who calculated and how it was calculated?
Makes no difference.
Makes no difference.
But once a right has been accrued and once a regression was
Your right could not have accrued. It accrued because of wrong calculation.
Correct. Right accrues because of wrong calculation.
No right accrues by wrong.
litigation, Your Lordship. Earlier 3 times this honorable court intervened and
Once for all, we will close it.
my lord, let a copy be solved and I will come prepared with the judgment as my lord.
No.
said.
Has the court relied on any precedents that if the calculation is wrong, the person is given appointment, still he will continue because the calculation is wrong by attributing it to somebody else?
Miscalculation does not make you more competent. It makes less competent.
My lord, it has been dealt with by the
And Mr.
single.
Parda, the difficulty is that
My lord.
there will be some 1 lakh candidate who will having more marks than you if the wrong calculation is made.
I bow down, my lord. I bow down.
Nothing.
My lord, let a copy be solved.
Yes,
and,
yes.
yes. We'll come
Since it is
prepared.
for fresh admission, but
All right.
Yeah.
Issue notice. Sri
GN person.
GN Parida,
Parikal. The accepts notice for the respondent employee. In short, point relating to comparative merits of the candidates is involved, which is arithmetical in nature. Call this matter on 31st of July.
That's that. My IA,
Really, we are condoning.
that's my IA is first stay.
For stay.
Stay up in from
Why any contempt or anything is made?
I don't know. That's application.
My lord, an opportunity should be given to me to file objection to the IA for condonation of delay because it was filed in days.
You on 27, you 31st you do it. Because he has that.
Item 19.
Yes.
See, state appeal industry is order of
Yes,
Well,
sir.
this is state appeal, my lord. When it's order passed by the honorable single judge, my lord.
Come to the mic. Be a little louder. See how your friends are arguing. Yeah, be that way.
This state appeal, my lord, against the order of the honorable single judge, my lord, directing the state respondents to pay the period for which she has not worked, my lord. That is from the period of, my lord, 92 to 2011, my lord.
92 to 2011, she has not worked at all.
Yes, ma'am.
Sir, she was working, she was not paid. That is how that is.
1 second.
She was working.
1992,
My friend is no.
92 to 2011, my lord.
2011.
My lord.
Almost.
Initial,
Rohit, you can sit down.
initial, my lord, initial the respondent was appointed under the private management school, my lord. At that time, the state school
teacher.
was as a teacher, my lord. Was not requisite qualification, my lord. The he has appointed against a post of a Hindi teacher not in the district of the middle English medium English school, my lord, ME school, my lord. That is their reading, my lord, standard 6 and standard 7 students, my lord. So for that, my lord, the government taken over the school, my lord, in the year 1992 with effect from 1991, my lord.
It was taken over by the state.
By the state, my lord.
In the year?
In the year 92, my lord, with effect from 91.
Huh? With effect from
1991, my lord.
1991.
One, my lord.
Take over.
My lord.
Huh.
And her post was not approved, my lord. As he was not requisite qualification, for that reason, his post was not approved. He approached the learned, my lord. He approached the learned tribunal, my lord. The tribunal directed to consider his case. Accordingly, the state authority rejected her case. They again challenged that order before the tribunal, my lord. And tribunal directed my lord.
That you challenge before the in writ.
My lord.
And
Subsequently, he terminated and she also reinstated by virtue of the order of the tribunal, my lord.
Terminated on which date?
Well, in 2009, my lord. And it reinstated in 2011, my lord.
Huh?
And it reinstated in 2011, sir.
2009. They don't have culture of giving the date at all.
Yes, my lord.
How we should know? Every date will be relevant in service matter. And when was she terminated from service? Why should not you have a small note before arguing? See, great lawyers, you don't see, you don't read their books. This is the problem. Always you should make a note. Date of appointment. What is she?
And she was,
when she reported for duty. What is her qualification for appointment? When she stopped coming to the school. When she came back to the school. No note at all. I am not saying anybody using the note at all. Unless you are extraordinarily brilliant, we don't require. But we don't see that brilliance.
When
the takeover happened on which date?
91.
Date, not year.
1/4/91.
1/4/91.
My lord, firstly, this is barred by limitation, my lord, more than a year. And secondly,
Mr. Purohit, applications disposed of by this court, by the writ appellate court on grounds of delay, starting with say 100 days up to 500 days. About 1,000 cases now have been remanded by the Supreme Court.
Then where is the court?
Each case depends on its own merit, my lord. Therefore, there can be no general principle that 350 days or 700 days delay can be condoned. There cannot be any such principle.
That you have argued, we consider that.
Secondly, my lord.
Yes.
Secondly, the court has the power to condone the delay under Section 5. But it has no power to condone the negligence and laches, man.
How many days delay?
And the laches I can explain from the fact that he has also faced a contempt petition. Contempt, the court had given 1 month's time to implement the order. But neither he has filed any extension of time, nor has he complied the order of the court. And 7 months thereafter again he has filed this writ appeal. Therefore, this amounts to willful laches, my lord. Willful laches. Since it was within his knowledge that the contempt petition has already been allowed.
Rohit, actually, a little information to you.
Well,
when you are saying he, you mean that the person, the officer,
no, my lord, the government.
The officer doesn't have authority to file any petition. You must realize that.
Unless authorized.
Unless it is the decision is taken at the top level.
It's a process.
My lord, where can the decision be taken? 1 year limitation?
Questions.
No.
Please, I'm sharing some information. If you don't like, I will not say it. Fair enough.
No, I am saying that the government has done this, not the officer or not any personal.
Government is not identifiable. It's a faceless individual. Even the person cannot enter where the decision is taken. This person cannot enter there.
Well, condoned delay subject to making some payment.
Lectures can also be done, sir.
We'll consider all that. How many days delay?
Let them give a copy thereof to me, my lord. They have not given a copy also.
Why are you
5 days, my lord.
Huh?
3 days.
But he is saying that copy is also not given. Although he has argued without copy.
It has come.
But you should have given the copy.
It has come for first time, my lord. We'll serve copy to him.
First time it has come.
First time it has come.
Okay. Why I thought that already he notified.
He's internship.
You are not you appeared already.
Yeah, appeared right.
He just filed the case and swept over the matter. Right from 2024 till 2025.
Not Saturday, we have a filed memo.
We'll condone delay if you agree. And on payment of rupees 5,000 to you. General trend in the apex court is when state appeal is involved, it stands on a different footing. Earlier we are holding the state on par with the rest of the citizens. It is not like that now. Therefore, you accept that money and come prepared for the argument next day. We'll hear you. All right. State appeal is filed after booking.
Not my acceptance, but
this is court order. After booking a delay of long delay of
390 days.
390 days. An application supported by the affidavit is also filed, seeking its condonation. First one. Learned AGA appearing for the AGA SC.
Yes, my lord. I am serving the copy of the.
Yes, give that copy. Always you should share the copy.
Yes,
It will fail. Learned standing counsel. Additional standing counsel appearing for the appellant submits that in matters like this, decision has to be taken at various stages, and thus there is a long process. During the accomplishment of the process, delay has been proved. 7. No prejudice should be caused to the other side if the same is condoned. 7. If not condoned, state would be put to prejudice, which is not good thing to happen, since state is a faceless entity and works through the individuals. Next paragraph. Learned counsel appearing for the respondent employee vehemently opposes the application, contending that when there is a huge delay and lapses, courts should come to the aid of state at all, state being a model litigant. He also submits that the explanation offered for the condonation of delay is far from satisfactory, and the right having accrued to his client after the lapse of a long period, that right may not be taken away easily. Next one, having heard the party. Yes.
The contempt case may also be taken note of.
He also submits that this appeal is filed only after the contempt court fixed the time for implementation of the imbued order, and thus the application for condonation of delay lacks bona fide. First. Next, having heard the learned counsel for the parties and having perused the papers, we are inclined to allow the application in as much as there is a plausible explanation for the delay. 7. The contention that merely because contempt court has fixed a particular time for implementation of the order, would not take away the plausibility of the explanation. First, in matters like this, decision is taken at the highest level after a due process, and therefore delay more often than not happens. First, there are arguable points from the in the merits of the matter too. First, next paragraph. In the above circumstances, application is allowed and one more sentence. Condonation of delay not add merits to the appeal to the disadvantage of the respondent employee. First, in the above circumstances, application is allowed and delay is condoned, subject to the condition that the appellant shall pay collectively a sum of ₹5,000 to the respondent employee within 2 weeks. Failing which, application stands automatically rejected, peremptorily rejected, and therefore appeal also would.
What is the date may I fix, madam?
No, let him pay ₹5,000 first. If they do not pay, appeal is dismissed. That helps you.
Next matter is also analogous.
90 days. 390 days. Any contempt proceedings were done than that? Same.
Same.
Identical. 5,000.
So my IA therefore increased. My IA is increased application therefore stay of the
stay. Let us see. Let us see, because contempt is there.
Yes, ma'am. Contempt.
Matter shall not be precipitated till next date of hearing. Date of hearing.
Contempt is disposed of. Second contempt I have not
But they have fixed time there.
They have not served any extension of time.
No, we are not passing any orders. You have not had.
No.
Mr. 30th of July. Or 31st of June.
The cost also applies to a second case, madam.
Same applies.
Different petitioners, so obviously possible there.
Item 21.
Say 3 days delay deferring the appeal, my lord. 3 days.
No.
90 days.
90 days.
790.
Sorry, I have 407.
790 days.
Here is a case, my lord. The president of the district consumer has appointed a stenographer without proper procedure, my lords, that in terms of the Uma Devi case, and he has not raised the matter in the recruitment board constituted by the government, and direction was given also to the district consumer forum under Annex of 3 series to place the matters before the committee is constituted, and prior approval has to be taken before appointment of the stenographer. Lordship, see that Annex of 3 series. Though in similar matter, your Lordship dismissed my case on the ground of delay, Lords. I have given that order. Your Lordship should look at the Annex of 3 series. Page 25.
25.
My lord. Page 25, last paragraph, my lord. To
obviate
all such difficulties, government have been pleased to decide that recruitment committee constituting of following functionaries may be formed for each district. That is president of district consumer forum, representative of the collector, DWO, CWO.
This was dated?
Dated Miller's 3996.
3996.
Petitioner has been appointed.
Appointed on?
That's 1
13/3/1997.
13/3/1998.
97.
And joined at 14/3/97.
13/3/97. Yes. Appointed by
District Consumer Forum, President District Consumer.
Oh, only President, not the committee.
Not the committee. And thereafter, Millers.
29 years.
Wait.
So he still works as a what chowkidar?
Stenographer.
Junior stenographer.
So in some places they're writing in hand with hand. Stenographers in real shortage in consumer courts.
That is
everywhere.
So you are utilizing it his services.
Make best use of it. That's all. Otherwise, already there is shortage. In fact, there is a recommendation for
What has happened?
Another day,
In fact, the original application which was disposed of by the tribunal, self-son allegation against the consumer forum, that has been upheld by the Supreme Court.
Yes.
And that has been followed
regarding power.
That is not Millers not referring that instructions of the government instruction. While deciding Miller's Sitaram Boy case.
And may I? That was no, only dismissed. Only dismissed. No. What has happened was just there are several cases have been disposed of in terms of that.
Obviously, courts concerned, you understand why.
Yes, certainly. You're absolutely because if it is dismissed in indulgence, but that is not
exercise of power by
yes, that I understand.
Conform to the constitution.
I follow why you are also asked that questions. No. All these cases, all these cases which have been disposed of one after the other, referring to that judgment, those are filed. In fact, this particular writ appeal, along with two other writ appeal number 2602 of 2024 and 1381 of 2024, are listed one day. But those two appeals have been dismissed on the ground of limitation. That limitation is 659 days in those appeal. Here is a delay of 790 days.
No, that's an individual case, and we don't agree.
Yes,
delay. We'll condone delay. We'll condone.
Yes, that's better.
But 29 years of service, that is how.
Now they cannot say this at this time. That appeal is preferred with a long delay of 790 days. 700 odd days. An application is filed seeking its condonation. First of all, the said application is supported by an affidavit. First of all, Learned Counsel for the state submits that delay in matters like this would ordinarily occur, and that delay be condoned to do justice to the case. First, Learned Counsel appearing for the respondent employee standing tall, although initially objected to the application, now agrees that delay be condoned and matter be taken up on merits. First, this gesture we appreciate. First, therefore, application is allowed, the delay is condoned. Next paragraph. The subject matter of this petition of appeal is substantially similar to the one we treated in writ appeal number 2602 of 2024, wide order dated 24/6/2025. First up, in that case, the employee had put in a long service of 29 years, although the entry to the service was arguably unauthorized. First up, we upheld Learned Single Judge's order which directed consideration of his case for regularization. First up, next paragraph. Learned senior advocate appearing for employee is right in telling us that like cases should be treated alike. The arguable misentry to the service may not be now reopened at this length of period, much water having flowed under the bridges. First up, apparently the employee appears to be in the near evening of her life, and asking her to quit now would be very disastrous to her lifeboat. First up, therefore, a writ court is also a court of equity, and it cannot afford to do such injustices. First up, next paragraph. Learned Single Judge, in his own way, has considered the matter with a human approach and has granted relief to the respondent employee. First up. However, broadly we agree with the reasoning of the Learned Single Judge, subject to one caveat that we would not close the issue of competence of appointment and the regularity of appointment, which may be examined by us in appropriate cases. First, however, that examination is not necessary in this case. First, in the above circumstances, appeal being unworthy of merits, liable to be and according to rejected. Or standing may be seen. Written anything to this? In fact, is copy should be nothing.
Now, item 22.
Yes, matter relating to the grant of pension to the block grant teachers, Miller. Lordship keeping it to the 20th July of 25. Learned AG will address these matters.
Covered by the judgment.
Argued by the learned advocate general.
Advocate General. We have posted it to 28.
28.
Call this matter on 28 along with other connected matters. Okay. Give that one number at least, connected matter number. Okay.
Item
That is
23.
Always keep hand that snake that wherever there is a hit matter, please.
Item 23.
23.
Pardon, Your Lordship. I am appearing for the respondent, Your Lordship.
Love.
You saw her a copy.
Yes, that's.
But how you'll receive? You are not available. Any of your colleagues is there?
Yes, Your Lordship. They're in the court.
Okay. This is item 23. This is data along with associates appear on behalf of the respondent. You have already filed Wakalatnama.
Yes, Your Lordship.
We
Submitted that they have filed Wakalatnama on behalf of the respondent. The learned AG is requested to serve copy on the learned counsel for appearing for the respondent. When do you want?
Your Lordship, this week, Your Lordship. Next week.
Released on 1st of August 2025.
I will serve copy on limitation petition.
Both. I feel memo along with I. We receive the copy too.
Item 24.
Yes, Your Lordship.
You do not stand behind when the matter is taken up. You are the arguing counsel. Mr. Shailesh Das for the appellant, B.K. Raj for the respondent.
May it please, Your Lordship. I'm appearing for the Appellant Service Commission, Your Lordship. I'm challenging the impugned judgment by which.
Pradhan, you can come to this side, or Mr. Patnaik, you can come to this side.
I'm challenging the impugned judgment, Your Lordship, where the Commission has been directed to declare the respondent as a selected candidate under physically handicapped category, Your Lordship. Now, the Commission has issued an advertisement for the recruitment of assistant agriculture engineer post, Your Lordship. Under that, there were 7 posts which were declared under the PWD category. Out of the 7 posts, only 3 were appointed. 3 were recommended for appointment.
Few means how many?
3. I'm so sorry. 3 were recommended for appointment, even though 7 persons have applied.
Notified vacancies were?
Notified were, Your Lordship, 5 posts. I'm so sorry, Lordship. 5 posts. 5 posts, 7 had applied, 3 were recommended for appointment. Petitioner's candidature was rejected on the ground that petitioner does not come under the category of PWD candidates who are eligible to be appointed, Your Lordship.
Category means any
Your Lordship,
percentage.
the percentage is not the question, the type of
Physical.
yes, Your Lordship. I will straight away come to the advertisement, Your Lordship, which is at page 21, annexure 1 to the rate of period. The page 21. Page 21. Your Lordship has the advertisement, Your Lordship.
Yes.
So this is an advertisement recruitment to the post of Assistant Agriculture Engineer Group B, Your Lordship.
Yes.
Of Orissa Agriculture and Food Production Service. Your Lordship may come down to the table which has been given. The
1, 2,
total
3, 4.
Yes, 2 is vacancy position. 130 number of posts were advertised, and just below that, NB. Out of vacancies mentioned above, 4 posts are reserved for ex-servicemen, 5 posts are reserved for PH
Physically
persons. Your Lordship. Now the next para, which is the issue involved here. Further, it is clarified that 1 leg affected MNR
MNR means?
Your Lordship, MNR is mobility not affected.
Motor neuron.
Your Lordship, mobility not affected.
Mobility not?
Mobility not affected.
Not affected.
So the person.
But R.
I will show the where the abbreviation has been explained, Your Lordship, in the notification. Then PD is, Your Lordship, partially deaf. Bracket with suitable aid categories of disabled are suitable to the post of assistant agriculture engineers. Then PH persons with disability of one leg
affected. So this is enlarged. So
One leg affected. One leg affected.
Your Lordship. May I read, Your Lordship?
Right or left?
right or left and partially deaf.
Yes, should be able to perform work by standing, walking, speaking / hearing and seeing. It is important in this case, which is required for the post of assistant agriculture engineer, full stop. Only those persons with disabilities whose nature of disability is permanent and 40% and more shall be eligible to apply for the post, Your Lordship. Now, it is my submission, Your Lordship, only persons having one leg affected MNR, which is mobility is not affected, and persons who are partially deaf, but they have suitable aid, are the eligible PWD candidates who can apply for the post. And that is hinged with the caveat that they should be able to stand, walk, speak, and see, which is required for functioning of this post.
That will not be met by the candidate.
Because he is a visually handicapped person.
How much visual handicap?
40% and more, Your Lordship, permanent.
But Apex Court has appointed 40% blindness as a judge.
Your Lordship, there is a provision under Section 32 of the PWD Act, the Central Government Act, which has given power to the state government that you can identify posts
which they can perform and which they cannot.
Yes, and that exercise has been undertaken, and there is a notification of 2013 by the General Administration Department.
What is the job chart of this concerned person? What he has to do?
The job chart is not on record, but as it appears, it's a field job usually, because the assistant agriculture engineer, yes, they have to be on the field Group B post.
No, whether 40% this is ocular disability is more than 40%. Less than 40%.
The more than 40%. It's on a record. There is a certificate that more than 40%. Low vision, more than 40% is the disability which the petitioner has.
Even with specs.
Even with specs, Your Lordship. That's the permanent disability.
Permanent disability.
Permanent disability. So my submission, Your Lordship, only two kinds of disabled, physically handicapped persons which have been delineated in this clause can be allowed to apply to be selected as per the provisions of this advertisement. Now,
but this argument was made before the Supreme Court also in Tamil Nadu matter, because in criminal cases, in trial, the judge has to see the material objects, weapons.
Your Lordship.
And that contention is rejected by the Apex Court.
But Your Lordship, here is a case where...
Do you know that judgment?
No, Your Lordship.
There is such a judgment. The matter went from Tamil Nadu. And the person was blind. It could come almost blind only. Blind candidate came to be appointed. He was the denied appointment. That opposed the Madras High Court. Then Madras High Court granted an order saying that he should be appointed as a judge. Matter went in appeal to the Apex Court. Apex Court agreed with Madras Court.
I will go through the judgment, but Your Lordship, I have one submission to make, because that's the appointment, the rejection of the petitioner's candidature by the service commission.
Karnataka High Court followed that.
Lordship,
take out that judgment. I don't remember. It's KRISHNA DIXIT on blind appointments.
Lordship, I will go through the judgment, Your Lordship.
I have referred to that judgment, Apex Court judgment also.
Lordship, I will go through the judgment.
They are misleading the court, my lord. I will case 66.
But you want to go through the
No. In previous advertisement, they have selected low vision considered as the selected candidate. My lord, the judgment of page 66, para 26. My lord, kindly page.
In the earlier notification they have appointed.
Yes, my lord.
I have an answer to that, Your Lordship. That impugned judgment at paragraph 9 specifically records that there was one post reserved for visually handicapped person. Your Lordship.
Yes.
There was no, that's not it. Question is not that. Question is on the functionality. Is there any complaint from anybody that the person who is the appointed now is not in a position to discharge his duties because of ocular disability?
Your Lordship, why the visually handicapped person was excluded, that was excluded. Let me submit. Why it was excluded? It was pursuant to a exercise conducted by a joint committee of the state government. I will just show the notification which has been filed pursuant to Your Lordship's order. Lordship may only come to flag C, which is the affidavit filed by the applicant.
Page in the writ appeal or in the writ petition?
In writ appeal, Your Lordship. In writ appeal.
Page?
Flag C is the affidavit dated 11th December 23.
Copy of GA department and resolution.
Yes, Lordship. Now, Your Lordship may see the annexure, the page 4 of that affidavit.
The state of Karnataka versus Lata action. Just look into this judgment. 11th November 2024. Just give researcher, you give whatever material is available. Just look into that judgment.
One more aspect that this employability of the agricultural engineer was passed out. Was it a condition? Was his handicap was progressive, or he took admission when he was also 40% blind or beyond 40% blind, permanent visual disability? Because this is a very specific course. Agricultural engineer, these are specific
job chart they have to do. Job chart. In that matter, we insisted upon job chart.
Yeah, Lordship, my submission is that once the advertisement has specifically...
Anyway, look into that judgment, that this judgment gives parameters as to how we should judge ocular disability.
Lordship,
and functionality. We have made some research in that.
They have filed this document, my lord.
Please be patient. We are
requesting you to see the judgments of other courts.
Lordship, I will go to and come back.
Let knowledge come from all corners, all directions.
Lordship.
So if it comes from Karnataka, why should we reject it? It may not be binding.
I will assist to Lordship after going to the judgment, Lordship. I will assist to Lordship after going to the judgment.
Both of you go through that judgment.
And let us not be blind towards law also.
So they have explained in their appeal.
They have explained how they are blind towards law.
No.
Oh, that's the short point.
Just look into it.
Blind towards law for judges at least is a problem.
John,
maybe it's not that difficult for a lawyer being blind towards law, but for judges it creates a problem.
John Milton was a blind man. When he wrote that Paradise Lost, he was a blind. And when he wrote Paradise Regained, he had ocular capacity. Many blind people have attained very great height.
Ladhan Bose.
Many. I have enlisted what all great people were blind people in that judgment. Therefore, I requested you to.
I will go to the judgment.
We have done some work of that. And there are resolutions. There are UN resolutions. UN resolutions are there for protective resolutions of physically handicapped, ocular disability. On that, separate resolutions are there. Therefore, just by one notification, you can't say that we should interpret it that way. Many aspects are involved. Just go through. You argued very well. Just go through. You may also go through because you have to defend. Can you get that Tamil Nadu judgment? Where a blind person is appointed at JMFC.
They don't have a computer here. This crowded place. I suggest I can have that. See all the
Just look into.
Okay. Nata, you are having?
Lordship, this is a state of confusion.
All this I am accumulating actually.
Yes.
Should I take you to the
Item 30.
See, when you come to court, youngsters, we are telling you.
Lordship.
First, what you should do, we have 25 high courts, one Supreme Court.
Lordship.
Is it not? How various high courts have viewed this point?
Lordship.
That is advocacy.
Lordship.
Not coming small reading and few sections, coming and arguing. Who will hear your arguments? Is it not? We also want some new things.
Lordship.
Therefore, study comparative jurisprudence.
Lordship.
That's very important. That gives you a different angle. How foreign courts have treated this. How European courts have treated this. How African courts, Australian courts, and how various high courts have treated this. What medical science says on this. Go to ophthalmology, consult a doctor, say this is the position. Several aspects are there. Advocacy is not a small thing. You should be wide open. Many angles, interdisciplinary effect, all these things should be looked into.
Lordship.
I come date fixed. Huh? Date, yes. Dates we can give, provided you come with more preparation. In the second week of August 20, short date. So dates are also of various sizes in Arabia. Some are short, some are big. Yes.
Item 30.
First of August. First of August.
First of.
Lordship. Can it be on, I'm so sorry, Lordship, can we have 4th, Lordship?
Yes, fourth.
Before. Selected candidate since 5 years.
Item 30.
So there is a arguable point because there are certain specific jobs reserved for you.
So they have explained in their application.
So no, don't say everything to know. That leads to my legal blindness. I'm trying to also get enlightened by all of you.
Well, what's your name, brother? You want to give your name?
Tarun Patnaik.
The state's criminal leave petition against the acquittal judgment passed by the London trial court, my lord. The TCR is not there, my lord. Lordship will call for the TCR.
Call for TCR.
Pardon, my lord.
Sufficient.
I am appealing on behalf of the respondent number 1 and 2, Lordship.
How many are there?
3 are there, my lord.
Yes, sir. Lordship, one small submission, Lordship. On the last occasion, Learned Counsel for the State has also submitted that the respondent has no right to participate in the in this proceeding to that is leave for appeal, Lordship. So I want to place some rulings before this honorable court. In the meantime, I may be permitted to place the same, my lord.
That 1980 Supreme Court.
Yes, my lord. Other judgments are also there. May I be permitted?
Yeah, the Monty had prepared a very nice note. I enjoyed reading that. You were right.
Yes, please.
The Lordship also given opportunity to the accused during the hearing.
So he should be heard in the matter.
Item 30.
But again, not to disengage. Where is the appellant?
Mr. Sanjeev Mahanti.
Pass over, call her to 24 hours, years here.
He has worked for 24 years.
Because not against the sanction court.
For 24 years,
Delhi OJs.
Maybe you have not disengaged. That is not also coming. So please wait for Mr. Man.
Item
virtual mode.
May I please, Lord? Hearing this case, my lord, the OP number 3 chairman OJE has filed a counter, but the other opposite party has not filed a counter. The challenge is very, very simple. The outside state candidates are not allowed to apply for the post of BSc nursing, for admission into the BSc nursing in our state. That is the subject matter of challenge here.
Outside.
Well, test 23. That is the point I am challenging.
Only domicile candidates are.
Yes.
But that condition is imposed by
the OJE, but the government rule or policy that is not there on the record. They are not filing out. Kindly see, my lord. Just I am reading out what is the provision. 23. My lord, towards bottom, my lord, last word, one paragraph. Please note. My lord, got it. Please note. Towards bottom, my lord, last word 1.
Annexure 4.
Annexure 4. But after that bold person, please note that outside state candidates. My lord, got it.
Please note that
outside candidates are not eligible for admission in government colleges, but they are eligible for admission to private colleges for all above mentioned courses, except all nursing courses as per the Odisha government rule. I didn't find any such rule, my lord. And this is also, if accepting that, suppose there is a rule, it is not permissible. Recent judgment of my lord in that Dr. Tanvi Vail case in PG medical course, my lord knows that January 25. This the Honorable Court has also held so that you cannot restrict
under 16.
My lord.
Place of birth.
Yes.
Place of residence.
Yes. This is violation of Article 14. 15 and 16 both, my lord, have considered.
16, huh?
Yes, essentially 16, my lord. My lord have also considered 15.
Well, where is why you are giving this reported judgment it is?
Yes, now I don't have the book, I got it from the net. That para 29, 28, 29, that is there, my lord. 29, 28, 29, 31, 32.
DP Joshi versus State of Madhya Pradesh is the first judgment of.
Yes, that's taken note of. Many things has been taken note. And but what they have stated in the counter, my lord, now one thing. What they have counter now is they have filed by OP number 3. They say subsequently they have issued a notice that yes, we are allowing only for admission to these outside candidates in the private management quota seats, not for all. That is also a restriction they have imposed.
Now, where is the rule which prohibits? This is only
I didn't find. Yes, this is the
joint entrance examinations.
Yes.
Which is the rule? Which rule prohibits?
I am for the OJE, OP number 3.
Yeah.
We are only conducting examination as per Step B3.
Who has issued this?
As per
Step they have issued.
You have issued. On what ground you have stated this? Others from states are not entitled to.
No, but subsequently, as per their instruction, OP number 5's instruction, we have issued 29 January notice. Thereafter, on 8 May 2025, as per annexure if by 3, the notice has been modified and
diluting this. They are not diluted.
To the extent, my lord, I have stated. Kindly see, my lord. There is 40. Running
management quota.
Only management quota, that must be.
But as per annexure B by 3, dated 4/11/2024, issued by Government of India, Skill Development and Technical Education,
Odisha.
The second para, we are therefore requested to take necessary steps to conduct entrance examination of the aforesaid nursing courses from the academic section 2025-26 and submit the merit list. So we have only conducted the examination and submitted our merit list to the chairman state nursing.
So kindly answer the query from what fell from my lord. That on what basis you have put this condition in the advertisement?
That's what.
B3, and it's a B3, there is no restriction.
Right.
On your own showing. I mean, we are not saying that you are not competent to hold the examination. Then you have to rely on B3 to say that you are holding. Then, but you are attributing it to 1 and 5.
Yes.
For 5?
My senior Mr. Mohan.
My lord, I have given the counter.
Yeah. No counter.
I have filed the counter. I have given the copy to you.
When have you filed the counter?
Counter. No, I have not received.
I have also not received.
My friend is there for Mr. Mohan.
Yes.
I have filed the counter. There is noting also there, my lord. I have already filed the counter.
When do you want, Mr. Mahanti? You
Just now is serving.
My lord, in the meantime, there is second special JE, OJE has been going to be conducted on 29th. There is also specifically they have mentioned and government has also mentioned for the outside state students to appear in the examination. And but they are, because this is for the management quota, therefore the management quota, they can also get admission. Because
Government's college itself.
no, in all management quotas, private colleges. All. Yes, added also. Not those who are having the government quota seats, there they can have the admission. Because we are having 85% in government allotted seats and 15 for private management. So we have allowed them in their seat, they can take a management.
From Delhi? No, here, in the same road. You don't want to come to court?
No, my lord, yesterday I was suffering from fever. That's why I was in these things. I can come. No,
does not happen, we cannot do justice. Otherwise, you are your matter, we pass our orders. Whichever way.
No, my lord. I have given this today. Regarding the second special J, there where we have specifically mentioned that the outside state students can be taken admission to appear in the examination, and they can be given admission as per the results.
But Mahanti, could you mark the submission of Mr. Das? Hopefully you have marked his submission. He says that it has been done by the JE. Now the JE shifts it to you that as per the instruction of OP5, we have confined
Do you permit your friends' clients to take examination?
Yes, my lord.
She's saying yes. What is that?
Yes, he is saying yes. But I think
so we have allowed, and I have given today the memo where I have given that the notification is there. Our direction is also there that we will allow the outside states to appear in the examination.
Kindly look at us.
Yes, my lord.
Look at the judges. We are asking you whether you are going to allow the petitioners.
no, the student, that the institutions who have come. Private.
Anyway, are you allowing these institutions to take the admission of outside state candidates?
Yes, my lord.
Then
Yes, my lord. That's what I have given today.
Purpose is over.
Look at the counter paragraph.
I have not seen, my lord. That is why is giving her. Which, my lord?
Sir, you give a copy to the court also. E-filing, when did you make e-filing? Date of filing.
No, all may not be necessary because he is saying we're meeting the petitioners.
Yes, I am not sure, sir, whether management quota or all the seats. You are permitting for management quota or all the seats?
All the seats, sir.
All management quota only, my lord.
This is the problem.
Management quota.
The seats he wants. For supporting management quota alone,
Yes,
what
my
is position? Which rule prohibits students from other state from taking admission?
My lord, I may be permitted, I may be given some time so that I can get direction from them. Why, on what basis they have done it?
He said, I wasn't sure. He's agreeable for you.
Yes, I will be happy for that.
Share that judgment also with your.
Yes, I am just giving a copy. I am giving a copy, madam.
This copy you can.
Yes, no, I am
Citation
I have an extra copy, madam. I am giving it. Let it be there on
Put
record.
the citation also. Keep it on record and the SEC or SEC online citation.
When next week, madam?
Next week.
Because admission.
Monthly on 23rd.
23rd, we shall have this matter.
All right, my lord. No problem.
Captain instruction.
Yes, my lord.
Yes.
As per item 34.
May I please announce it? And withdrawal memo has been filed on the ground of compromise.
For 3 minutes, I'm appearing for the petitioner.
Yeah.
No counter has been filed in this case, my lord.
Counter. Take the counter. You want to go through the counter?
Yes, my lords, I want to go through the counter. If necessary, I'll file a rejoinder.
Let's call this matter in the first week of August.
Interim order is there, my
At
lords.
the request of learned counsel appearing for the petitioner.
Petitioner.
Interim order obtaining shall continue.
Great.
Item 44.